the live streaming. Okay. Got it. Thank you. All right, good afternoon, everyone. The Public Defender Service Corporation Board of Trustees meeting of August 2022 is now called to order. Will the secretary please call the roll?
Chief Justice F. Philip Carbolito.
I am present and I'm logged on from my residence at Nimitz Hill.
Presiding Judge Alberto C. Lamarena III.
He's excused.
Trustee Cynthia V. Ikubi.
She's welcome.
Present. She's turning on her mic.
Just for the record, QB, if you could just acknowledge that you're present.
Yes, Your Honor, I apologize. I was having difficulty trying to get in. So I am here present in Agantya, Guam at my law office. Thank you.
Trustee Donna Munya Canasta.
Yeah, she is excused.
Guam Bar President Jackie T. Terlahi.
Good day. This is Jacqueline Terlahi, logging on from Las Vegas, Nevada.
Thank you, Jackie, for logging on from Off Island. I appreciate your presence, and as a result of you logging on, we have a quorum. We're able to conduct the business of the board this afternoon. So the first item on the agenda has to do with the approval of the minutes of the regularly scheduled meeting of June 28, 2022. Is there a motion to adopt?
I'll move to adopt, Your Honor.
It's been moved by Attorney Ekubi. And Jackie, is there a second?
Second.
All right, thank you. It's been moved and seconded. Any discussion on the minutes? There being none, all those in favor, please say aye.
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 Those opposed, it's been unanimously adopted by those present at the meeting. So the first item under old business is our financial status update and our allotment releases. And so I will acknowledge Mr. Mike Moreno. Mr. Moreno, you are recognized.
Thank you, Your Honor. Good afternoon to the board. Since the last board meeting, the Department of Administration has been consistent in releasing the allotments. And as of today, we are anticipating 3 more pay periods. So I believe they will be releasing it accordingly. That being said, public defender and the alternate public defender are at 97% today. As for the domestic violence program, the sexual assault grant funding for STOP 2018 has been exhausted as of June 30th, 2022. For STOP 2019, there was a balance of 1,800. However, this amount will be returned as the program had expired as of June 30th, 2022. The remaining available STOP 2020 grant has a balance of 3,300, from which we will be invoicing for the month of August. As a note, reimbursements of payments made in advance for the STOP programs are received regularly within 30 days after submitting their invoice. Another grant still available for the domestic violence program is the Improving Criminal Justice Responses Grant, or the ICJR. The total funding available of ICJR is $115,000, which will be used for the reimbursement starting as soon as the STOP 2020 funds have been exhausted. For the Elder Justice Center, for a total of $138,194 invoiced as of July 31st. Receivables as of today are for the months of November 2021, April, June, and July 2022 for a total of $69,000. EJC is in constant communication and is working with DSC to follow up on the release of the rest of the receivables via the Department of Administration. And that concludes the financial reports for this board meeting. If there are any questions, thank you.
Thank you, Mr. Moreno. Why is there so much delay in the payment of the invoices for the Elder Justice Center?
It's as far as I understand it, they are still auditing our invoices, and they still have the payments will not come through as long as they're holding on to our invoices. So what we are trying to do with them in our communication is trying to fix any discrepancies if they have any, so that they can submit that to DOA. So far, they have remitted 2 months prior to this meeting, and the result is in November, April, June, and July, the 4 months still pending.
So Ron, do you have any insight as to why there's questions? I mean, I don't know the form of the invoice and, you know, what the contract provides. But
I'm sorry. I think Gwen might be able to address that better than I.
all right, Glenn, do you have any insight as to why there's so much delay? Is it just they have so much work, or they actually have questions regarding the accuracy of the invoice?
Hi, good afternoon. So it is not a question on the between EJC and DSC. It is the invoices, all of it is now with DOA. And so that is where the lag is coming from, is with DOA and also with the Office of the Attorney General. And so I understand that's where the delays are coming from. We are constantly in communication with DSC, and they assure us that there is no question on what we have been submitting.
So explain to me why the Office of the Attorney General is involved in reviewing the invoice of the Elder Justice Center.
I'm not too able to speak all the way on that, but I understand that they are still, you know, they do auditing of our invoices as well.
Yeah, Kathy, can you meet with whoever is the financial officer that oversees the Elder Justice Center's invoice review and just kind of get a handle? I mean, that, you know, where there's several months and, you know, it seems to me that since payroll is being met and expenses are being paid, that the public defender is able to advance the funds and then get reimbursed. But I just want to know, you know, what the issue is, and maybe we can try and assist in expediting this.
Will do. I'll get that done for the next board meeting.
All right. Okay. And if you get it before then, just give me a call and just let me know. And if we need to speak to Mr. Byrne, then, you know, let's go ahead and do that.
Okay. Gotcha.
Any questions for Mr. Moreno?
Mr. Chairman,
Yes.
I did have a question regarding the lapse in months. I thought I heard November and December, and then it jumped all the way to April. Is there a reason that we are not following the chronological months?
I believe Gwen may be able to answer that question because he's in communication with DSC directly.
I'm sorry, I didn't understand what you said, Mike. Can you read that again?
If I can defer the question to Gwen.
So Gwen, the question is, why is November, December outstanding and January, February, March paid? Isn't it first in time gets paid first?
So that is a question we've also posed to DSC, and we've asked, you know, how is it that it gets paid out? We were thinking that as we are submitting, they should be getting paid in the order of the months that we are submitting. And we've been provided email communication showing that, you know, that the reports are being submitted timely and follow-ups are being done. And so we haven't been given a reason as to why they're not being paid as they are being submitted. And why some are, you know, like the later months are being paid versus the earlier months. So we haven't received a good answer, Your Honor.
Jackie, any follow-up questions? comments?
No follow-ups. I think it's really important to take a look. I don't know, Gwen, if you're looking at the invoicing from a monthly perspective where we're dividing it on a per month basis, equivalent through the 12 months. Are the invoices actually changing? And I guess that's the question, right? So if the invoice is changing from, let's say, 100 and some thousand in December, 100 some thousand in January, and then all of a sudden it increases to 200,000, perhaps that's what's triggering kind of the audit. I don't know, but perhaps that's where you can take a look at the invoicing and see if that's what's creating the discrepancies.
I will get back in contact with DSC here today and ask that we just get more information on this and to have a better answer for everyone.
Yeah, we understand they're very busy. They have a lot of work, but you know, if we're not in their face, they're not reminded that there's a payment that needs to be made. So I just think that we need to be a little more aggressive in following up. If we haven't, I don't know all the facts and details, Gwen, but I'm just saying that, you know, maybe we need to take more of an interest and just follow up, whether it be in writing, in email, and if there's a need to speak to other people to try and assist, then please just let us know. All right. And Steve, you know, maybe you might want to step in on this. And
We'll take care of that, Your Honor.
all right. Okay. Thank you. All right. The next item on the agenda, there's no further questions for Mr. Moreno, is the report from our Executive Director of the Public Defender Service Corporation. And Steve, you are recognized.
Okay, thank you. I mean, I guess everyone's aware the budget's being discussed by the legislature, so we're just keeping our fingers crossed that all of our proposed amendments make it into the final bill. But so far, it seems like without jinxing anything, all of our proposed amendments have made it through scrutiny. And so, I mean, I guess the only things we really attached were the questions the board had about our conflict procedure. So we attached a standard operating procedure that had previously been approved by the board. So this is the SOP used by the staff, legal clerks, secretaries, paralegals, investigators, and attorneys. And so that everyone's involved in the process of screening for conflicts.
Yeah, you know, PJ Lamarena was the one that raised this issue, and he's not present, so let's just keep it on the agenda for the next board meeting. But I mean, I was the Chief Justice in 2014 when we adopted this, but you know, in reviewing the SOP, and you know, the practice may modify what's written there. But once the litigating attorney makes the determination that there is a conflict, and then his next step is to file the motion to withdraw, is there another set of eyes that reviews the initial determination, Steve, by any supervising lawyer in the corporation?
Not currently. I know that we, constantly discuss this during our morning meetings, but we don't really have a separate checkoff. We do have supervising attorneys in every courtroom that we could hold responsible for that procedure. But
I'd like to suggest that we modify, and you take it back, and that we modify the policy in section 3 once the attorney creates an attorney note recording his or her determination and determine that there is a conflict, that there be some supervising attorney, whether it's Mr. Morrison, yourself, some supervisor, that reviews that determination and signs off as a co-signer in the motion to withdraw, indicating that there were two sets of eyes that looked at this determination that there is a conflict, and it calls for a withdrawal, and that there's, as we've spoken, there's no other steps that can be taken to try and either wall off or in some way address the conflict short of a withdrawal and not breaching of course, the rules of professional discipline. I just, with all that's going on and I just would suggest that we modify the written policy if it doesn't exist in practice. And if it does exist, let's put it in writing that there be another lawyer, supervising lawyer, at what level, Steve, you can determine, who will review the determination that there is a conflict. And if he agrees, he or she co-signs the motion to withdraw so that there is an indication that it's been reviewed by management and agrees with the staff attorney assigned to the case. Would that be all right, Steve?
Oh, no, that's not entirely burdensome, and that's probably something we should do anyway. So we'll implement that.
All right,
Your
thank you.
Honor.
Yes.
May I also suggest, I think you raised an important issue as I was looking through this, and this policy was adopted in 2014. I'm not sure, and I know it may take some time. I know that PJ was very interested in the policy, but I think that it would probably be important if they could just look at any updates as of 2014. That's 8 years ago. I serve on the investigative disciplinary panel, and there's a lot of updates that have been ongoing. And I think that it would, since I think you raised a good point, Your Honor, that there'd be a supervisor who can review it to ascertain whether there is a conflict. But also, I think we should know that if there's any significant changes, especially with former clients, and whether there could be potential still representation of that, I think it would be important for this organization to take a look at it, because it's been over 7-8 years that this was adopted, and conflict of interest issues are hot topics both in the local and in the federal level. So I think it might be important if they could take a look at any changes significantly in the rules. I also am a firm believer that unless there is a conflict of interest that would preclude a attorney from representing a party, it should be incumbent on the attorney to take the representation. But more importantly, I noticed in the rules that there could be waivers executed. And if it's something that can be waivable, it's just in the case of disqualification of judges and justices, there's always an attempt to try to keep the case with that assigned attorney or the justice. So I think that that would be important just to take a look at, because I am aware that there have been some changes in the law related to conflicts of interest. If we're going to go through the process of possibly including that suggestion, Chief Justice, about having a supervised attorney, I think it's important that we should also look at the rules to ensure that there have not been any significant updates that we're not including. And I'm also a firm believer that I think that, and I'm sure public defender does it, but I think attorneys, besides every 2 years they have to do a CLE on ethics, it's important that this issue of conflicts of law should always be updated. There's so many changes, and as you pointed out, we really want to make sure that we're servicing the community, and that if there is a conflict, that there is no way that it can be waivable, or that the public defender or APD cannot accept the thing, then it should go to the private panel. But I think for now, I think we want to make sure that we are updated on these existing conflict of interest rules. And if it's going to be any amendments, we might as well include any changes with respect to the ethics rules relative to this issue, as well as you pointed out, the policy of including a supervising attorney to review the litigating attorney's assignment. Thank you, Your Honor.
All right, thank you, Attorney Akibi. Jackie, you're recognized.
Thank you. I was also going to recommend, Chief Justice, that perhaps we should make a recommendation to the Judicial Council to request assistance on an advisory committee for both, not just the public defender, but maybe also the AG's office. As Attorney Akubi has addressed, there is a lot of concern about conflicts issue. And now that we're seeing a reduced bar, and we have serious modifications to our rules, perhaps it's time to assist our entire criminal justice arm with reviewing kind of the conflicts process. I think sometimes when we have the outside bar membership, the private bar practitioners, perhaps they can give some fresh eyes to both the public defender and the AG. So I don't know. I also, of course, want to wait for the PJ on his views of this policy, but perhaps now is the time maybe to form some kind of recommendation to our Judicial Council. It's just a recommendation.
All right, I will look into this further, and we will pursue, at the very minimum, some continuing legal education. I try and do this for our judicial officers at every opportunity when we get faculty, ethics faculty presenting, that we address the conflicts and recusal and the various rules that apply and how it may be addressed short of getting up a case. You know, as Attorney Akubi points out, while we have an ethical responsibility to recuse ourselves, meaning judicial officers, if there is a conflict, we also have a duty to sit, and that balancing sometimes is examined so that we can try and stay on the case, of course, and if the lawyers agree. But I do see, and I'm glad that the Clerk of Court of the Supreme Court is on the Zoom meeting, so that I'll work with her in assisting in reference to trying to set up also some continuing legal education where we make recusals and disqualifications a topic in reference to trying to provide training, because it's you think it's the rules, but these issues can get complicated, and how you resolve it. Expert faculties in the field can offer some suggestions. And so we'll make this a topic. I'll try and do this within the various organizations within the judiciary, and try and assist both all the attorneys, the PD, AG, and also the private attorneys. Which brings me, and so thank you for that, which brings me to the statistics, because I think the data is going to be very important to whoever we engage to assist us in this regard. And raw numbers are really not helpful to me, Steve and Kathy and John. Let's put percentages in reference to the rate of disqualification for each category. When you say that 53 out of 332 had conflicts, and I assume withdrew it in those number of cases, I think when we compare percentages across the different cases, across the years effect and that are in play, it will be a little more meaningful when we look at the graphs. Also, percentages are helpful to assign to raw numbers, and so if you could add that to your table, then we can utilize the statistics in a more meaningful way in any discussion. So that's my request, that you go back and add another column adding percentages, and so I don't have to take out my calculator and do it for each item. Any other comments in relations to the topic of disqualification?
No.
All right. Okay, so let's move to the next item on the agenda. And sorry, I closed the So, Steve, is there anything more that you wish to add in reference to your report?
No, I mean, we have the stats, but we'll put the percentage. And really, once we started showing up at magistrate hearings, we actually withdraw, or we don't get appointed to cases where there's clear conflicts there. So that would actually tend to make these numbers lower than they would have, because in the old days, we would just get everything and then we would do a conflict check. And we found out we were getting appointed cases we never should have, if, and the conflict should have been identified, at magistrate. So I think our attorneys are trying to identify the ones at magistrates. So that also reduces the number of actual motions to withdraw due to conflict.
All right, all right. Thank you. I don't have any further questions, and if there are none, we'll by the other trustees. We'll move to the next item on the agenda, which is the report of the APD Managing Attorney, Attorney Annie Gell. You are recognized.
Good afternoon, Your Honor. We put this together. This is the top part is all the incoming for the month, for the fiscal year up the month of July. If you notice, for Clyde Lemons, he is no longer with our firm. Pete and I Mr. Santos and I just cleared his cases, and we both took on his cases. Those cases, his cases are closed, those ones that are still there. Down below, you have the conflict. I guess you would like you want a percentage, Your Honor?
Yeah, that's helpful to me in reference to comparing the figures. Raw numbers are not that meaningful to me without the percentages as we compare it, over the years, and just see if we're increasing, decreasing, how it compares in reference to the categories. And, if there's a substantial amount, I guess we can do a deeper dive and maybe start looking at, the various reasons why. I'm sure that there are obvious reasons, but just in reference to providing any faculty member that we wish to engage in helping us navigate the whirl of disqualifications and recusals, and just educate us or the lawyers. That would be helpful in my mind.
Okay, we can do that, Your Honor. But I think Mr. Hattori is correct that since being at the magistrate's hearing, sometimes we'll both have cases that even the magistrate will say, I'm not going to appoint you because I already noticed that he's been with someone else for a long time, or for whatever reason, he won't appoint us. But another issue that does appear, or it does happen, is that without that third review, Your Honor, the second or third review that you're asking for, is sometimes the conflict shouldn't really have been a conflict. And by the time we figure out that it shouldn't have been a conflict, we've already been appointed to it. So that's just one of those things with the judges. So I guess it is probably a good idea at this point to everybody be aware of and get updated on conflicts and be aware of the new rules or case law that has come out regarding conflicts. That's all I'd like to say. Thank you, Your Honor.
All right.
Yeah, and Your Honor, I just want to add, there was a recent ruling by a trial judge where the government actually moved to disqualify APD on what they perceived was not a conflict. He found that there was a conflict and they were forced to get out, and it was like at the pretrial conference level. And so it's not like I don't think anyone's really trying to get out of it, but we have to move to withdraw. Otherwise, the government's gonna do that at the 11th hour when they don't want to go to trial. They'll move to disqualify the office, which is what happened, right, Ms. Gill?
That's correct. It was People versus Clarence Aldon. I'll get the case number. I can forward you the decision and order, the board, so you can see it. This is the type of issues we're dealing with the Attorney General's office.
All right.
Thank you, Your
Anything
Honor.
else? Thank you. So if there are no other questions for our APD managing attorney, let's go to the report of the Elder Justice Center and Mr. Ron Haynes. Ron, you're recognized.
Thank you, Your Honor. We're providing this chart of statistics of cases opened, cases closed since the beginning of January. You can see the numbers are pretty well consistent. August 12th, we've already closed 24. As far as the pending cases, those were never actually opened and not officially opened because we were waiting for confirmations, for communications from people. We sent out letters to all of those we couldn't reach by phone, and have closed those cases. Have just closed the files because we never opened them in the first place. There was never enough communication to do that. So those are no longer on the table. You can see we've closed 305 cases so far this year as of August 12th. And then on the right there, the powers of attorney, last will, those are what we've done in those cases. Some of them, many of those cases, every one of those documents were done, others a few less. Then the statistics below are our outreaches. Grant source requires us to do 1 a quarter. We far exceed that, of course, because we're continuously trying to let people know that we exist and to build a presence in each community. So we're continuing to do that. We do lots of outreaches, have appeared at conferences, and there on the right is this statistic of how many home visits we've been doing. You can see just in August, we've done 9. Those actually consume a lot more time, of course. And that was 9 as of August 12th. I think we've done 3 more this week. So, last week. And, we're continuing to do that. If we could go to the next page, you'll see that one of the things that you had asked for was for us to see what our stats are looking like as to people calling and what they are looking for. And of course, these are not large numbers particularly, but you can see there's every single month we get at least 1 landlord tenant call. And that's without advertising and actually informing people a lot of times that no, we don't do that yet. We only do, the wills and advanced directives, things like that. So I think the numbers are there to begin to look at these cases. We've discussed deed of gift a lot, and we're getting calls about the deed of gift, asking if we would do one. We, of course, as you know, we're not doing that yet. And so you can see the statistics there. The bottom chart is what we've done with those calls, when they come in, where they go. Oftentimes they go to the Guam Bar's referral, and then you see some other places that we've sent folks. Those numbers will correlate with the numbers above. And I will say that we've called, Ms. Diego called the Guam Bar and Ms. Gogui as well, and trying to see if we could get statistics of what happens when a call comes in, but they don't keep those statistics. So there wasn't anything for us to refer back to as to what happens to those cases once they get there. So those are the statistics. And then we have, we have attached the extension of services, what we're hoping to do and how that fits in, as well as a lot of statistics on page, I think it's page 32. Yes, 32. As to what the Tennessee Senior Alliance group had done to give you an idea about what other senior programs are doing. This is Tennessee, and if you ask why Tennessee, well, that's my old program. This and the page before, page 31, has the words of the executive director, Deborah House, of that program, and said that they had a special grant to do seniors over 4 years from the Tennessee Senior Law Alliance. So this is just that program and how many cases they've done. And you can see on those statistics on the left, they kind of group them all together: the housing cases, the education cases, employment cases. And you'll see under housing, 437 cases. And these are just seniors. And of course, their demographics, I think they cover, well, I'm not sure now how many counties they cover. Of course, it's a lot larger population than we have here, but it is just to give the idea of what's going on. Number 63 in this list is the landlord tenants, and they have done 192 cases in that 4-year period of time. Actually, I think it's closer to 3.5 years, but they had 192 cases in landlord tenant. And so that is when I used to be with that program, I know I did a lot of it myself. And that is one of the reasons why when we talk about expansion, we talk about landlord tenant pretty much first. And the reason for that is shelter being an absolute priority for our seniors, making sure they have shelter and just making sure that the leases are abided by, they aren't taken advantage of unfairly. So it is one of the things that we hope to expand to. It is our first expansion request, and we have suggested that if the board is willing to go that way, that we would expand in that direction first, see how many cases come in, and then be able to give a response to if that is something that we should continue more of, if we should expand there further. It is something that we've been discussing with the board for several months about which ways to expand, and we've talked about landlord tenant and deed of gift. The deed of gift, we have suggested that there be a priority that so that we don't get overwhelmed with deeds of gift, and then we can help people in other sections like landlord tenant, and that we just limit it to a personal resident, that the client will be responsible for getting a title search and for registering any deed that we might help them with. So that's pretty much the overview of our expansion. And if you have questions, I'd be glad to see if I can answer.
Thank you, Mr. Haynes. I normally don't like to delay things and just bring it up for a discussion and then a vote and deciding one way or the other. But Trustee Donna Kanata, she has been a force in reference to wanting the Elder Justice Center to expand some of its services, and she's not present at our meeting to advocate one way or the other. And so I'm reluctant for us to push this forward and dispose of it without her being present, and of course the presiding judge. And so I feel that if there's going to be any expansion, this is the first time you put forth a plan in which you are proposing to phase in various expansion of services and do it in intervals. So my thinking, but I'll leave it also to the other trustees as to how they wish to what's their thinking is my thinking position is that we should have the other trustees available for this discussion because it involves an important element in reference to expanding the services of the Elder Justice Center, and Trustee Kanata has been a advocate of that. And I was just going to call on Jackie, and she got and she dropped. Okay, there she is. She's coming back on. All right, Jackie, you dropped just for a short moment there. And did you want to say something?
Thank you, Mr. Chairman. Yeah, I was going to make a recommendation to the Elder Justice Center that we have been operating for a significant amount of months at this time. In order to advance any action, I think it's going to be extremely important to provide us a little bit more data. If you're asking for landlord-tenant expansion, I'd like to see a number of requests. What number of requests are coming in with regard to disputes on leases or unlawful detainer issues? So I think the data needs to be broken down as opposed to just a land issue or a deed issue, that there should be more specifics about the need of our seniors. On the issue.
Okay, we got the gist of that, but we'll let her come back on. Okay, Jackie, I don't know if you could.
Chairman.
Yes, go ahead. Yeah, you froze and you.
Yeah, no, I got you wrong.
All right.
Yeah.
You can continue.
So I don't know how much I apologize. I'm going to turn off the video because I constantly have to hold the speaker to my ear. But essentially, I was making a recommendation on statistics, right? That if we are going to be asking for expansion, I think that the trustees should be shown the statistics broken down into each field, not a generic field.
Okay, Ron, I think you got the summary of Jackie's request, and that is that she is asking for data in reference to that there is a need for the Elder Justice Center to assist our elderly in the landlord-tenant relations as the first proposal to expand the services. And as you've mentioned, you know, it's not the fee generating type case. It's for those who really can't afford it. And it's just a natural to provide this service because we don't want our manamcos to be, you know, put out on the streets. And so I'm sure Trustee Kanata would be a fierce advocate in support. And so, but at this point in time, you know, let's table this until the
Yes.
next meeting. And Ron, this will give you more time to provide additional data that, and hopefully, you know, your office is compiling, and if not, then you should probably start in reference to the intake process. And if there is a need for an expansion of this services or an education program that now, you know, your office is in a position to assist and it needs supporting information. I'll leave that to you, how you provide support for your request rather than just a request and, you know, comparing, providing statistics from the Tennessee jurisdiction. That's really not relevant to us other than, you know, they are engaged in this type of service for our elderly, for the elderly. And so that, you know, and it's just a matter of, you know, the priority and in terms of how we devote our resources. And if you feel that as the managing attorney, that this is something that would greatly assist and help out this segment of our community, then be a strong advocate for it and have it supported with relevant data. Okay, all right. We see Jackie's message, and Ron, do you have any questions in reference to the request?
Yes, actually. So I just want to qualify that what Mr. Terlaje is suggesting is that we get data, not just when we get a landlord-tenant call, but that we continue the intake process and try and break it down as to what the landlord-tenant call is about, as whether it is an unlawful detainer or whether it is a landlord overcharging or keeping a security deposit. I'm guessing these are the areas. I will say it's pretty hard to get those statistics when, first of all, we meet a call at our front desk. Our front desk people are not lawyers, but simply taking information. And so I'm not sure they're going to be able to separate what the legal issues are. And then secondly,
I don't think that's what, let me just stop that. I don't
Yeah.
think that's being asked. Just what's the
Okay.
nature of the complaint? My landlord wants me to leave and,
okay.
what's the nature of the complaint? You don't have to have a legal analysis as to whether there's merits to the complaint. That's not what's being asked here.
Okay, good. Well, that's what I was trying to clarify.
And
Great, thank you, Your Honor.
Your Honor, we'll work on, I mean, it's not hard to get a survey sent to all the senior centers. That could be done by the next board meeting. So we'll make sure something like that happens. So we actually have a needs assessment from our own Mononco.
That's very good, Steve. Yeah, that sounds very, that's a good way of trying to see it established that, there is a need short of having people call in. And so I think that would be very helpful. Okay, so we are done with, I assume, is there anything else, Ron, in reference to that Civil Law Center? I just want to make sure that I didn't cut you off.
No, Your Honor, I think that's where we're trying to go at this point. And, you have the numbers of what we've been completing. As far as orders of protection, we've been doing those as well. So I think that covers.
All right, thank you.
Thank you.
All right, there's no items under new business and in reference, thank you for adding, but we can't do that under our open government law, just modify our agenda, but we can do it under public discussion. Teresa is here and we can do under public discussion the swearing in of the new lawyer, Teresa Dunphy, to the temporary admission for the practice of law. And the necessary pleadings have been filed and it's just subject to completing the character and fitness report in order to remove the temporary admission part of it. And Hannah, is it only now for us to swear her in so that she can start practicing here in our jurisdiction until we complete the character and fitness report?
Yes, CJ, that's correct.
Okay.
It will entitle her to conditional temporary admission, and she can be.
Okay, that was the word I was looking for. All right, okay, Teresa, you are under the spotlight, and I'm going to ask you to just provide some background in reference to your legal training prior to joining the Public Defender Service Corporation, and what practice you did prior to joining for the information of our trustees, and before I swear you in.
Okay. Well, I was licensed in California, and I've only practiced in California, but I took the Oregon bar as well, just in case I needed it. I mainly did criminal defense in private practice. I interned with the public defender in San Diego, and then a few private attorneys, and then they picked me up just to work with him full time. It was just a single man firm, but he took a lot of the conflict cases from the public defender. So we had most of those in San Diego, a lot of high-end gang cases with Mexican mafia and then the local gangs. And then, just regular DUIs and everything else. But that was primarily what I did. I did work at a boutique IP firm for a little while. I needed health insurance. So that's why that went down. But yeah, it was mostly criminal defense is what I do.
Well, good. That's the nature of your job when you join the public defender, and it's good to know that you have litigation experience and you can hit the job running in reference to having experience in the nature of the work that you are being hired for. And so Steve, I'm very pleased that you have added Teresa.
Actually going to be with APD, Your Honor.
Oh, APD. Okay. And
Yep.
sorry
We're all
about
in the same umbrella, but she's
Yes,
with
yes.
APD.
Okay. So
For now, right? Daddy? No, I'm just joking.
yeah. All right. So with APD, very essential. And so with the second line of work, second line in reference to our recusal process before we get to the private attorney panel. And that's good that we're beefing that up, Annie. And it's good addition to the office. So with that, Teresa, I'm going to ask you to raise your right hand and repeat after me as I administer the oath for you to be admitted to the Guam Bar. I solemnly swear
I solemnly swear
that I will support the Constitution of the United States,
that I will support the Constitution of the United States,
the Organic Act of Guam,
the Organic Act of Guam,
the applicable statutes of the United States,
the applicable statutes of the United States,
and the laws of Guam,
and the laws of Guam,
that I will maintain the respect due
that I will maintain the respect due
to the courts of justice and the judicial officers,
to the
courts of justice and
courts of justice and the judicial officers,
that I will conduct myself honorably
that I will conduct myself honorably
as an attorney at law,
as an attorney at law,
and that I will abide by
and that I will abide by
the Guam rules of professional conduct.
the Guam rules of professional conduct.
So congratulations, Teresa. You're now conditionally admitted to the Guam Bar with full rights and privileges,
Thank you.
which means that you get to practice in our jurisdiction.
That's cool.
All right, so we're done. Any member of the public wishing to comment, bring anything to the attention of the board? There being none, at this time, we don't have any other matters before the board, and so I will entertain a motion to adjourn
I'll move, Your Honor, to adjourn the meeting.
until September 27th, 2020 at 12:30 p.m. when our next regularly scheduled meeting is set for. So moved, Attorney Ekubi, and seconded by Attorney Terlai.
Yes, seconded. Thank you.
All right. Thank you, Jackie. So there being no objection, we have concluded our business for the day and we stand adjourned. Thank you, everybody, for participating and providing.
Thank you, Your Honor, and thank you, PDSC.
All right.
Thank you, everyone. Thank you, Jackie, for zooming in from Las Vegas. She's
Thank
already
you, Your
off,
Honor.
huh?
And Teresa,